All right, let's proceed.
Good morning, Your Honors. My name is Phoebe Coddington from Winston & Strawn, and I represent Bank of America N.A. and Bank of New York Mellon in 3 out of the 4 consolidated cases before you. I'd like to focus my talk on 4 things: the statute and summary process rules, the Hemingway and Fafford non-title defenses, and public policy.
Could you just, as a quick question, one of these cases settled. Could you just remind me which one it is?
The Rosa case settled, Your Honor. This is a simple case of statutory construction. The Housing Court erred when it failed to give effect to every word in General Laws, Chapter 239, Section 8A. Section 8A states in pertinent part, "In any action under this chapter to recover possession of any premises rented or leased for dwelling purposes, the tenant or occupant shall be entitled to raise by defense or counterclaim any claim the plaintiff has relating to or arising out of such property, rental, tenancy, or occupancy." This statute provides only for one category of defenses and counterclaims in summary process proceedings: those that both relate to premises rented or leased for dwelling purposes, and that arise out of or relate to such property, rental, tenancy, or occupancy.
With regard to the counterclaims here, if the counterclaim plaintiff, the defendant in this case, were to prevail on all of them, would their prevailing in any way prevent the eviction? Would there be any part of that counterclaim which would permit or require a judge to say the eviction cannot go forward?
I do not believe so. I guess there's a possibility of, if title has already passed, then there would be an equitable relief of rescission or maybe reconveyance. But stopping the eviction itself for some of these affirmative claims, I don't believe there would
There's
be a
one
possibility.
case in which there are title questions about, right? But so I think Justice Gann's question, putting that one aside. Because if there were title questions, it could stop it. But apart from that, you're saying that the other counterclaims would not have any effect on the eviction itself. Is that right?
Correct. That is what I'm saying.
So the 93A or the discrimination claims, they would not have any effect on the eviction itself.
We do not believe that those go to title, and so they are not cognizable, because the only question under summary process is whether the summary process plaintiff has possession, and in post-foreclosure, it's whether the title has passed properly. And so because those claims don't go to that question, they're not available in summary process.
How do we do with the Cater case, where we said, although we didn't in that case order it, that the reconveyance is an available equitable remedy under 93A?
Reconveyance in itself assumes that title is already passed. And so it's different than the situation that would stop and say that title never passed, which is what some of these claims purportedly are trying to do. In the Cater case, it was a 93A claim alleging wrongful foreclosure because the foreclosing entity was using the foreclosure to try to get Cater to testify falsely. And in that case, the court found that although the defendant had the legal right to foreclose, the reason they foreclosed was unfair, and that gave rise to the 93A claim.
Is your Chapter 239, Section 8A claim based on the premise that there was no landlord-tenant relationship?
Yes.
But that the statute talks about a tenant or occupant.
It does.
And why aren't these people occupants? Because you have to go through 239, Section 8A to get rid of them, don't you? So the statute seems to contemplate something broader than a mere tenancy.
239.
Well,
239.
239, Section 1 gives 7 different bases for people to use a summary process procedure to find who has superior rights of possession. But what Section 8A did is it limited the ability to bring counterclaims in summary process to only those that have a rental or tenancy relationship and for dwelling purposes.
How old is that statute?
1965.
Right, 1965. And changes to what's equitable and what can be brought in which court, all of that came after the fact, as did Wayne. And none of these events have caused a change by the legislature in this language, right?
True.
So there have been subsequent determinations, including in Wayne, as to really what was meant, right? So wouldn't that continue as a thread? I mean, that involved a foreclosure as well, didn't it? So we weren't speaking in Wayne about strict tenancies pursuant to a lease or a rental agreement?
No, Wayne spoke to the foreclosure process itself.
Yeah.
And so it's different than when you have a rental or tenancy. I mean, I think the case law shows that a post-foreclosure occupant does not have a rental or tenancy relationship with the new person who holds title.
But so if that's true, then the person who holds title could go out into the street and disconnect the water, disconnect the sewer, disconnect the gas line, and all those other things that they couldn't do if it was a tenant. Wouldn't that be the result?
I think that's not really before the court right
No,
now.
but isn't that the result of what you're saying?
I think if it's a new owner that is entitled to possession, they have all rights of ownership. If title is passed, they own the property.
They go take the roof off the house.
Whether there's a conditions defense outside of this has been decided adversely to post-foreclosure occupants in Gabriel. They're not allowed to bring condition defenses. Those defenses can go potentially to a use and occupancy claim. So if there's a problem with the premises itself, having no water, the locks don't work, there's no heat, that might reduce the use and occupancy payments that the occupants are supposed to pay to the new title owner, but it doesn't go to the claim of whether the title has passed. I mean, the title is passed in this situation if they've complied with the power of sale on their respective mortgages and followed this court's precedents and the statutory constraints that are provided.
But if the bringing the counterclaims is not going to affect the possession question, or most of them, what's wrong with bringing them all together? And then you get your possession, and you continue to litigate the rest of the claims.
The legislature had. Its considered judgment was that these claims had to be brought separately. In Fafford,
Well, you say that, but why do you say that?
because 8A reads
But
specifically.
8A could be interpreted as it's written in 1965. There's been no rules of civil procedure in effect. It's very clear that equity and law don't go together. So it is making an exception at that time for a particular kind of landlord-tenant rent withholding and other kind of relief. But now we live in a different time.
I understand, Your Honor. The merger of equity and law has come into effect. There are different changes that have happened, but the statute seems clear to me that it is limited to the circumstances provided. In Fafford, this court actually rejected the judicial economy reasoning provided there, and I think the same stands here. The legislature decided that these things had to be brought separately, and that is how the statute's written, and that's how the court has to define it.
But the focus there was really on the commercial versus the residential, wasn't it?
It was, but to decide differently in this case, you'd still have to ignore certain words that are in the statute. It's rented or leased for dwelling purposes. You can't raise dwelling purposes above the other two words
No, I don't
beforehand.
think you wouldn't do that. You would say that statute deals with a very particular kind of counterclaim. That doesn't mean that other kinds of defenses and counterclaims can't be brought.
I read Fafford a little differently. Fafford,
I'm not just talking about the statute. I
Then the
understand the
statute,
way you,
which-
I understand that, and I don't necessarily disagree with you about Fafford itself.
well, what I was trying to say is to go, what Fafford, when it looked at the statute, it decided that it looked at Wesson versus Leone, and that changed the doctrine of independent covenants, just like Hemingway did for the residential context. And even recognizing Wesson versus Leone changed the context of the common law, it still made a determination that counterclaims, including those that could be brought under Wesson versus Leone, were not available. It made a blanket rule that counterclaims outside of the statute were not allowed.
Now, Judge Kerman thought that Fafford and Hemingway were irreconcilable. What do you think?
I respectfully disagree. I think Hemingway marked a huge revolutionary change in the common law to recognize the covenant of dependent covenants. And in so doing, the court determined that there was now a common law defense, and then decided that the tenant who was in Hemingway was allowed to bring that claim or defense in that summary process context.
Permitted by 8A or no?
Yes. I mean, the counterclaim that was brought would have fallen in both parts of the statute. It was for a rented or leased for dwelling purposes, and it arose out of and related to that tenancy or lease. And so it falls within the statutory constraints of summary process. So I don't believe they're in conflict.
Now, would it matter if the tenancy here was one of sufferance? And is it indeed a tenancy by sufferance, since they have remained there?
I don't believe it is. And that issue is not, I guess, I don't believe they are tenants at sufferance. I mean, there is case law that says if they are tenants of sufferance, they don't lose the defenses that they had before. But these people were never tenants, or they never entered into a tenancy or lease with the summary process plaintiffs.
Counsel, your time is up.
Thank you.
May it please the court, good morning. Thomas Santalicito for Federal Home Loan Mortgage Corporation, which is better known as Freddie Mac. The housing court is a court of limited subject matter jurisdiction, and this court has tended to construe the housing court's jurisdiction narrowly, with the understanding that the legislative purpose behind the court was to address landlord-tenant disputes and issues involving substandard housing. The court has expressed concern in prior cases that expanding the court's jurisdiction vastly would have the effect of delaying cases that are within the court's core mission, as well as distracting the court and diluting its expertise. We believe that an expansive ruling by the court permitting counterclaims or non-title defenses outside of Section 8A would give rise to those concerns, would distract the housing court from its primary mission and focus the court on issues other than
But
landlord-tenant.
on your theory, I take it, you're very unhappy with the Bailey case, right? I mean, it's expanded, in your view, the housing court's jurisdiction. It may take them beyond their core mission to deal with all these title questions, but
No, I
we've
would
decided
disagree,
that.
Your Honor. The Bailey case stated what this court has long held, that the paramount issue in these post-foreclosure summary process actions is whether the plaintiff possesses legal title. Once the title has passed and the plaintiff can prove its title, the judgment for possession must enter. So the Bailey case said exactly that. It just reiterated what had been more than a century of previous law, that that the issue in these post-foreclosure summary process cases is which party has the superior title. Allowing the housing court to hear these types of claims would also potentially infringe on the jurisdiction of other courts that have a more general grant of jurisdiction to hear these types of issues, like the Superior Court and the Land Court, who have statutory jurisdiction to hear quiet title claims or to issue declaratory judgments. The holdover mortgagor's position would be that the summary process be essentially a look-back provision from the origination of the loan all the way through the foreclosure, being able to bring any possible defenses that may exist over that time, where the court in Bailey and in Wayne and Wing has stated that title, or previously the regularity of the foreclosure, is the only issue in these cases. Also, the housing court does not, in summary process, does not present an ideal form for complex mortgage litigation. The discovery rules in summary process are extremely limited, do not provide for depositions, do not provide 10 days to respond. These discovery rules are incongruent with some of the complex mortgage litigation claims that homeowners counsel would prefer to bring in summary process.
Are they not involved in some of the title issues that are now clearly permitted after Bailey?
Can you repeat that, Your Honor?
Are they not, these narrow procedural windows and so forth, the non-taking of depositions, all of the limited discovery and so forth, don't they, aren't those things somehow implicated in the more complex title issues that are now permitted to be raised after Bailey?
I don't think Bailey changed anything. I think
Bailey changed anything?
I think Bailey restated what was the common law for which the court expressed in Wing and in particularly the Wayne decision, that the sole issue in a post-foreclosure summary process is which party had the superior title. And the limitations as far as discovery and the logistical pieces existed before and have existed since Bailey. The issues we're speaking about are the non-title defenses.
But I'm just saying that the title defenses can be very complicated.
Absolutely, Your Honor, they can be.
So all of these procedural hurdles that you're talking about as a reason for not expanding this to the counterclaims that have been brought here, I just wonder what the difference is.
The procedural rules do make it very difficult. Some of these title claims can be somewhat difficult. So the court does have some flexibility to modify its time frames or its discovery orders to provide additional time.
But doesn't the housing court hear these kinds of counterclaims in the general run-of-the-mill landlord-tenant case?
In the landlord-tenant cases, title isn't so much at issue.
Yeah.
Matter of fact,
But all these other claims that you describe as a distraction to the court, the court handles those on a daily basis, doesn't it?
the court handles similar cases, but in mortgage litigation, we're often dealing with multiple parties, banks that are located out of state. Again, 10 days to respond to a discovery order requesting loan documents that are in the property of a custodian located out of state is very difficult. It can be done, but if the court takes an expansive view of the housing jurisdiction, the housing court's jurisdiction, at some point these procedural impediments become even more pronounced, where more issues are brought in, more parties are brought in, which is why we would request respectfully that the court continue to construe 8A as it did in Fafford and hold that the only issue available in a post-foreclosure summary process action is that of title. Thank you very much.
Thank you.
Good morning, Chief Justice Ireland, members of the court. I'm Dick Bauer, along with my colleague Eloise Lawrence. We represent three of the homeowners in this case, Seferino Rosa, William Ogbamudia, and Dora Batista. The fourth homeowner is represented by Marilyn and David Flores. Ms. Flores will speak after I do. The homeowners in these cases have alleged, and this court must accept this as true at this stage of the proceeding, that the banks, in violation of the federal Home Affordability Modification Program, HAMP, and of General Laws Chapter 93A, unlawfully refused to consider modification of the homeowner's mortgages. Had the mortgages been modified, the mortgage payments would have been more affordable and the foreclosures might have been obviated entirely.
So you would get so the relief there would be to undo the foreclosure, is that right?
That's correct. To the extent the bank said that that relief was not what we were seeking, that is incorrect. That is precisely the relief that we are seeking, and on this posture of the case—
But you claim title. You claim superior title.
That's correct. Either in all four cases, we claim superior legal title, but in addition, we claim in at least some of the cases that because the mortgages were unlawfully not modified, that there's a defense there to possession because modification of the mortgage would have made the mortgage affordable and obviated the need for a foreclosure.
So why is that not an affirmative defense as opposed to a counterclaim?
I think, Your Honor, it is probably, it might be both. In the case of the discrimination, this court has treated discrimination as an affirmative defense. It has never, to the best of my knowledge, dealt in this context with whether the 93A claims would be an affirmative defense. Our practice has been to plead them both ways. This court in the Eaton case noted that homeowners could use counterclaims to challenge the foreclosure. Frequently, such claims are treated in litigation more or less interchangeably. We are concerned not with the title of the claim, but whether the homeowners can raise these issues in these post-foreclosure summary process cases.
But it does sort of make it, I mean, if you treat it as a defense, it seems to me it's closer to this title issue and possession issue than if it's a counterclaim seeking damages. Which
I think that that's correct, Your Honor, and seeking to undo the foreclosure could be characterized, I suppose, either way. In these cases, the homeowners are also, at least in some cases, seeking damages. But there's no reason why those things should not be available here. As Justice Duffley and Justice Bosford had noted, Since the 1960s, the legal landscape has changed, and the legislature has made it clear that it wants all of the issues relating to possession to be decided in the summary process case.
Right, but isn't that the crux of the issue, that it's related to possession? Is it your position that a counterclaim that would not affect possession should be within the rubric of 8A?
It is not, Your Honor. If it does not go to possession, it would not be within the rubric of 8A. This court in the Hemingway case expressly ruled that counterclaims are available in the residential context outside of 8A. Contrary to what the bank said earlier, Ms. Hemingway was not within 8A. This court expressly ruled that, but ruled that nonetheless she could bring counterclaims. So the court's predicate here, which is that no counterclaims are available outside of 8A, is directly contrary to this court's holding in Hemingway that counterclaims are available. If they do not go to possession, a court could appropriately, and the summary process rules recognize this, sever those claims so as not to delay disposition of the possession issue. That would go not to whether they could be brought, but procedurally with how the court would choose to dispose of them in the case.
But Hemingway, she was a tenant.
She was a tenant, but for purposes of 8A, that didn't help her because in addition to having to be a tenant, 8A also has certain other requirements about notice. Ms. Hemingway did not meet those requirements, and she was not within 8A. So the fact that it was residential, the fact that she was a tenant, didn't help her. She couldn't bring claims under 8A, and this court expressly ruled that. But it went on to say, nonetheless, she could bring counterclaims outside of 8A if she chose, even though those would not go to possession.
So your position is that these are counterclaims outside of 8A?
Yes.
You're not attempting to fit within 8A?
We are not for purposes of this case. I think Justice Spina was correct in noting that 8A also talks about occupants. And so whether the appeals court was correct in Gabriel in ruling that 8A is limited to tenants, we think is questionable, but this court need not decide that in this case because under Hemingway, counterclaims are available in the residential context outside of 8A.
How far can a court go in terms of mortgage modification, if it can do anything at all?
We are not, in this case, Your Honor, asking for any change or challenging any issues of substantive law. So a court would have to decide, as an equitable court always has to decide, what is appropriate under the specific circumstances. As the Qatar decision holds, it is possible for a court pursuant to Chapter 93A to order the reconveyance of a property. We are not saying that is appropriate in every case. That would be decided case by case. What's at issue here is simply the threshold question of whether homeowners can raise that issue in the summary process case.
But the court doesn't, you're not suggesting that the court has the authority to order a specific, well, I guess it would be the reconveyance. That's as far as it goes.
That might be the specific and appropriate remedy. It would have to be decided on a case-by-case basis. But the legislature, in expanding the role of summary process courts, creating housing courts, eliminating trial de novo, and expressly granting equitable jurisdiction exactly coextensive with the Superior Court to the Housing and District Court's hearing summary process, has granted them the appropriate authority to grant whatever relief is appropriate. The legislature intended that these be decided, these issues, which obviously go to possession, be decided in the summary process case, and justice demands that as well.
Including a specific mortgage modification?
A specific one based on the particular facts of the case, yes, Justice Spina, just as the Superior Court could do that, just as in an appropriate case, a housing court could do that. This case is not about the scope of the relief that's available. The question is simply whether the available relief is available in the summary process case or whether the homeowners have to try and go someplace else and run the risk that they will lose possession of their homes even though the foreclosure may have been based on improper conduct on the part of the bank.
Is there any legislative history on 8A that tells us what they were thinking?
Not, I think, that we know of, Your Honor, but we can, I think, infer some from what they didn't do. And what I mean by that is this. In the Hemingway case, as I've noted earlier, this court specifically held counterclaims were available, and the court acknowledged 8A, but specifically said it didn't believe that in enacting 8A, that the legislature meant to limit common law rights that would be created by this court. And subsequently, in Berman versus Jefferson, the court said the same thing, that it acknowledged 8A, it acknowledged amendments to 8A, but said it did not regard those as limiting the rights that had been established in the Hemingway case. The legislature has never responded to that by changing 8A and indicating that it disagreed with this court's view.
Would we have to, in your view, overrule Fafford in order to decide in your favor in this case?
I don't think that you do, Justice Bosford. We think that the assumption, I think, in Faffard that 8A is the only basis for Hemingway would make Faffard questionable, and this court may want to revisit it, but it's not necessary to do so. Faffard holds only that counterclaims are not available in a commercial case. Hemingway holds that counterclaims are available outside of 8A in a residential case.
But
And
it
this
really,
could-
I'm sorry, but it
I'm sorry, I
really
didn't
does,
mean
it really does characterize 8A as dealing with two things. One, that defines counterclaims. And two, that 8A itself talks about a landlord-tenant situation, which you would acknowledge is not what we have here, exactly.
This is certainly not a landlord-tenant situation, although it is established in this court's jurisprudence that the homeowners are deemed to be tenants at sufferance, and this court has expressly held that. But we would agree this is not a landlord-tenant situation. Whether homeowners come within 8A, as Justice Spina has noted, I think is frankly an open question given 8A's use of the word occupants. But this court could simply decide that counterclaims are available in residential context under Hemingway and still choose to deem them to be unavailable in a commercial context. This court has often treated commercial situations as different, where people are engaged in this by definition for a business reason, whereas defendants in summary process cases and the kind of defendants who face these kinds of cases, by definition, have very limited resources. They are accused of being in default on their mortgages, just as Ms. Hemingway was accused of non-payment of rent. And this court recognized, and Hemingway and the legislature recognized, that in that situation it was appropriate for residential defendants to be able to raise these things in a defensive posture. So this court could leave the line that it drew in the Faffard case between commercial summary process cases and residential ones and simply say that residential homeowners fall on the side that allows them to bring counterclaims.
Thank you.
Can I ask one
Oh,
question?
sure.
What do you say in response to the amicus brief of the Real Estate Bar Association as to what kind of havoc this would wreak in the recovering housing market?
I think, Justice Corey, that their argument is really that these issues should not be raised anywhere. But none of the parties to this case have said that, and this court has recognized recently, for example, in the Bailey case, that at least many of the issues that the Real Estate Bar Association talks about can be raised in summary process case. And the banks here do not deny that these issues can be raised as well. They just say, go raise them someplace else. So to the extent the Real Estate Bar says, should these issues be able to be raised, that argument finds no support from any of the parties here or in this court's jurisprudence.
Thank you.
Okay, my time is up. I now turn the podium over to Ms. Flores.
Good morning, Your Honors. I'm Marilyn Flores, and I'm here with my co-counsel attorney, David Flores, and we represent Gerard Giaffi, who is one of the defendants in this consolidated case. Your Honors, the facts of my client's case exemplify why relief must be granted to post-foreclosure homeowners in summary process cases so that they can bring counterclaims and affirmative defenses. My client, Mr. Giaffi, was foreclosed upon by Bank of America when Bank of America did not hold legal title to the property, as the mortgage was never lawfully assigned to Bank of America by Mears until after.
But Bailey makes clear that that claim can be brought in the housing court.
Yes, yes, it does, Your Honor. But I'd like to just tell you a little bit about the facts of my client's case, because there's thousands of other homeowners out here who are facing the same kind of basically torture from the banks. Usually when the homeowner is foreclosed upon, they don't bring a claim in Superior Court because they don't have the money to bring the claim. So they wait until they're brought into the housing court. When they're brought into the housing court, they want to raise their affirmative defenses, which they can, but they want to also raise counterclaims. Then they're told by the housing court that they have to take their counterclaims and raise them as regular claims in the Superior Court and file a motion to have it consolidated with the housing court. But what unfortunately happens in these cases is the banks immediately remove the cases to federal court. They're usurping the power of the housing court. They're taking that power away and they're giving it to the federal court, who has less interest in the homeowners of this Commonwealth. Now, when it goes to the housing court, many of these homeowners who cannot afford an attorney either give up their home to a bank that does not own legal title to the property, and if they do decide that they want to defend in federal court, they usually lose because the federal court will grant summary judgment because a homeowner who has no attorney doesn't know how to defend itself. And this is wrong. It's not justice. These cases have to be heard in the housing court. The legislature did not intend for these cases in summary process and these counterclaims to be removed to federal court. Because what happens is when they're in the federal court, when these claims are there, the housing court has to stay summary process until the federal court comes down with a ruling. And then you're faced with a res judicata issue. And then when the homeowner does decide to defend in federal court, and if they do lose on summary judgment, if they want to appeal the case, what the bank does is they file a motion for an appeal bond. And usually that's over $100,000, and the homeowner, again, will usually give up. Now this, as I've said, this is not justice, and the whole purpose behind summary process is that a homeowner and a tenant are both afforded just, swift, inexpensive determination of summary process. And when the banks remove this to the federal court, it compromises that. It doesn't help summary process, it compromises it, it slows everything down, it's more expensive. Now, we've brought 93A claims in this case because under 93A, there are unfair and deceptive trade practices involved here. And as I said, in Mr. Gioffi's case, Bank of America foreclosed when it didn't hold the power of sale under 183 Section 21. And when they did foreclose, they didn't comply with 244.14 as well. Now, Ibanez was decided.
So what's happened on those issues?
What has happened on those issues? I did.
They're going to title.
Excuse me?
Those issues clearly go to whether or not
The issues go to title. And what we did is we filed a counterclaim under 93A in affirmative defenses stating that the Bank of New York Mellon has no standing to evict my client because they received basically a Bevilacqua property. They purchased the home when Bank of America did not hold title to the property.
I thought that in the judge's opinion, at least in Amero, if I'm saying that correctly, said that all the parties acknowledged that those kinds of title defenses are absolutely fair game in the housing court.
Exactly, right? They are. But you can have an affirmative defense and have it also be a counterclaim at the same time, because much of the conduct, the illegal conduct that makes up the affirmative defense is also the grounds for a counterclaim. For instance, if you have a 93A affirmative defense, you're saying that they didn't comply with the statute, they engage in unfair and deceptive trade practices by foreclosing without the power of sale, and by not following the foreclosure statute under 244.14, you have an equitable defense because they didn't foreclose property, and therefore the foreclosure should be void. But in the same time, you also have a counterclaim because there's a remedy for those kind of unfair and deceptive trade practices. The legislature put those in place. The legislature has done this to protect homeowners, to put them on a more even playing field. If homeowners are not allowed to bring these counterclaims in the housing court, they're being denied equal access to justice because they can't afford to hire an attorney. And under 93A, it gives them more of an ability to go out and find a member of the private bar to represent these homeowners so they can fight these banks. And that's what the banks are afraid of. They don't want homeowners to bring these counterclaims in the housing court because then they're going to be able to get an attorney to defend them and to defend their title.
93A claims you can get counsel costs no matter where you file the lawsuit.
Of course you can. But the reality is, Your Honor, is many times when these homeowners are foreclosed upon and they're fighting the foreclosure, they don't know they have a 93A claim. They don't have the money to seek out counsel, and it's not until they get into summary process that they realize they do have these 93A claims and they want to raise them as counterclaims. But this whole procedural gauntlet that they're faced with when they're told to go to Superior Court and then it's removed immediately to federal court, they're being deprived of their homes. They're giving up their homes because they don't have the money to hire an attorney. If Judge Kerman's order, if his ruling is affirmed, you are going to see less vacant properties. You're going to see less foreclosures. You're going to see less vandalism in these vacant properties. You're going to see neighborhoods prosper. You're going to see less decline in the property values around the Commonwealth. This has had a devastating effect on the economy of the Commonwealth. Judge Kerman's ruling must be affirmed. It makes good sense. It comports with the legislature's intent to afford just, swift, and inexpensive determination of summary process. It comports with statutory law. It comports with common law. It comports with Eaton. It comports with Bailey. It comports with Hemingway. It makes good sense, and it makes good public policy.
Thank you.
Thank you, Your Honor.